Okay, I guess we'll go ahead and get started. Thanks so much to everyone for coming. I'm Corinne Blaylock, the Executive Director of the Law and Political Economy Project. This is the fourth event in our summer series, Mapping U.S. Law and Political Economy. And so I want to start by saying a bit about the concept for the series as a whole and what we still have coming up. The structure for the series is loosely in conversation with an article co-written by the faculty directors of the LPE Project, Amy Kipchinsky, David Graywall, Jed Purdy, and Sabeel Rahman, recently out in the Yale Law Journal. This article, titled Building the Law and Political Economy Framework Beyond the 20th Century Synthesis, among other things, tells the story of the transformation of law and legal scholarship over the last 50 years, accounting for the meteoric rise of law and economics in US law schools, the false separation of the quote-unquote economy from politics, and the erasure of critical traditions and questions of power. What Luke Herron and I hoped to do in designing this series was to move from this overarching story to accounts of specific areas of law by talking to LPE scholars about what happened in their specific fields. And so we have asked some of the most exciting LPE and LPE adjacent scholars to essentially be interviewed about their fields, to historically situate the current state of the law, to discuss to what extent and in what ways neoliberalism did or did not transform their field, as well as to point us towards the approaches and ideas they feel best challenge the current settled order. We have 2 more events left in the series. Next week, we will examine the criminal legal system with Jonathan Simon and Sean Osei-Owusu. And on August 12th, we will delve into US empire with Oz Labali and Aziz Rana. But tonight, we are ecstatic to have Kate Andrias and Veena Dubal here to offer a critical history of labor and employment law. And so I will turn things over to Luke so we can get started. Thanks, everyone.
Hi, everybody. I am Luke Herron. I'm the managing editor of the Law and Political Economy blog. I'll be your host this evening. But for the most part, we will be hearing from Veena Dubal and Kate Andrias. And who are they? Veena Dubal is professor of law at the UC Hastings School of Law and a major protagonist in the passage of AB 5 in California, which is a big victory for labor, for rideshare labor and other contingent labor in California. And I should mention, has been the target of some targeted harassment because of that, and including on webinars. So although we're pretty sure we'll be safe, just so that everyone's aware, we are alert to that possibility.
If someone flashes you, it's not going to be because of me.
And we have a contingency plan, don't worry. But just to give a sense that these stakes are very real. We're not talking about dead law and history. We're talking about really live campaigns and people's lives here, and people's money. And we're also joined by Kate Andrias, who is professor of law at Michigan Law. Why don't I just get right into it by asking Kate to start us out with just an overview of the US labor and employment system as it stands today.
Great. Well, first, I just want to say how really thrilled I am to be here. This series is so exciting, and I'm just so happy to be a part of it, and also to see all these amazing people, scholars, and activists and lawyers on the participant list. So we're really excited to be part of a conversation with all of you. So I think one way to think about the way the system of work law as it stands today is that it's really, for the most part, conceptualizes 2 different fields, as labor law and as employment law, kind of divided into 2 broad categories, with labor law referring to collective rights, the rights of workers to join together, to organize, to bargain, to strike, and then the second category being employment law, which defines workers' rights with respect to their employer on an individual basis. And there's many buckets. The employment law has many buckets within it, from statutes like the Fair Labor Standards Act, OSHA of particular importance today, the anti-discrimination statutes, state contract law, state tort law, employee benefits. And in some ways, this division of the field is, I think, a mistake, but that is really how it's conceptualized and how it's taught in law schools, for example. And I think as part of this conversation, we'll get to some of the problems with our labor system as it stands. But at the outset, I just wanted to highlight a few features, really core features or problems with the system, both the labor system and the employment law system. Both parts of that divide are really characterized by very minimal rights and very weak enforcement and penalties. So, and second, whole sectors, whole kinds of work are excluded from protection under both the labor law regime and the employment law regime. And those exclusions reflect our history of white supremacy, of xenophobia, of gender hierarchy. So I'm sure we'll talk about all of this more, but the exclusions of domestic workers, agricultural workers, of workers classified as independent contractors, workers who work in temp positions, and then whole categories of work that isn't even considered work, like unpaid care work, like prison labor. So that second key problem. And third, the system is really organized around the traditional employer-employee relationship in a way that is really deeply mismatched with our current economy, which is which is characterized by big apex corporations that subcontract multiple times over. It's highly fissured. In David Weil's terms. So, that I think sort of is just a sketch of how the field divides and some of the core problems with it.
Yeah, and maybe, Luke, if I can just sort of build on that a little bit, but first also to say thank you all so much for spending your evenings listening to us chit chat, and I hope some of the stuff we're going to say, many of you are the experts on. So thank you for listening, and we look forward to your comments in the Q&A, and also thank you to all of my mentors who are listening right now, who I've learned so much from Jonathan Simon to Julie Shore. It's really, really humbling to be able to speak before you in this way in my husband's closet, where I'm hiding from my children. So just to build a little bit on what Kate really beautifully and clearly laid out, the reason that traditionally labor law and employment law have been taught in these sort of two siloed classes, even though they are enacted on the bodies of the same workers, are because of the way that our statutory schemes and the administrative architectures of our system. So when we teach labor law, we're really teaching the National Labor Relations Act for private sector unionizations and the cases and decisions that come from the National Labor Relations Board. And then when we talk about employment law, we're sort of doing a really, or at least in my employment law class, we're doing a broad sort of survey of the land with regard to employee rights, beginning in the New Deal and post-New Deal, from Fair Labor Standards Act, the minimum wage, to Title VII, protections against discrimination at work, to the Family and Medical Leave Act, etc. I wanted to highlight and sort of grow Kate's comment on how labor law in particular, since its inception in 1935, actually has carve-outs for domestic workers and agricultural workers. It also doesn't cover public sector workers, I should say, and it wasn't really until 1959, I think, when Wisconsin created a framework for municipal collective bargaining that labor legislation in the U.S. actually included public employees in a legal framework for collective bargaining. And while public sector unions are really under attack right now, as you all know, they still have the highest percentage of unionized workers, interestingly. So returning to this idea that domestic workers and agriculturals workers were always carved out of the National Labor Relations Act, I think it's important to note that this was a facially race and gender neutral way to exclude African Americans and women from statutory protections afforded by collective bargaining. And it's been, almost a century since the passage of the NLRA, and there has been sort of no successful movement to include them in federal collective bargaining protections. What we've seen at the domestic worker level, we have the introduction of Domestic Workers' Bill of Rights as a result of work from the NDWA, the National Domestic Workers Association Alliance. And there have been sort of suggestions that because a firm-to-firm bargaining model wouldn't work for domestic workers, we should do either something more sort of, I think, deregulatory, which would be like a building trades hiring hall union model for domestic workers to bring up the standards as they've been brought up in other industries, or do a tripartite, a sectoral level bargaining model. And Kate maybe at some point today can talk to you more about the idea of sectoral bargaining, which is what she has written this really amazing article on. But I want to note that actually we have used the sectoral bargaining model for agricultural workers. So we have some state level laws that have tried to address the fact that federal laws carve out agricultural workers. The ALRA in California has unfortunately largely been understood as inadequate and somewhat of a failure more recently. And the fact that agricultural workers have been carved out of the National Labor Relations Act has resulted, as and this is true for the domestic worker movement as well, or domestic workers as well. It's resulted not just in really exploitative labor conditions, but abusive legal structures that exist at the intersection of race, work, and immigration law. So, for example, again, without these sort of agricultural protective bargaining or protective bargaining in this sector for 22 years, starting in the 1940s, we had the Bracero program, which was sort of this guest worker experiment program in which 5 million Mexican workers were brought to the U.S. to temporarily perform manual labor on farms. They were guaranteed 30 cents an hour for doing what we now call essential work. And, just like the sociology and the history around the Bracero movement is so deeply shameful. Workers were sprayed with DDT when they came to the border before they were handed over to these abusive middlemen. And again, this is 5 million people brought to the U.S. For the purposes of essentially exploiting their labor. That really, I think we could draw sort of a straight line to from the Bracero program to the exclusion of agricultural workers in the NLRA. The other group of workers that are excluded from the NLRA are independent contractors, which really didn't happen until Taft-Hartley and sort of more the focus of my research. But the exclusion of independent contractors from the NLRA has been a source, as I'm sure you all are aware of much consternation in the last decade or so with the growth of the gig economy and the hustle economy, and the misclassification of workers more broadly, where companies, in order to lower their labor overhead, try and make it look like they actually don't have employees that have the right to organize in their workplace and collectively bargain, but rather have independent contractors who are, small businessmen or business people who don't have the rights to collectively bargain. So that's sort of the collective bargaining scheme, and then we have all of these sort of individual rights that Kate mentioned that have grown from the New Deal. Sort of, we had this wave in after the New Deal. We had a wave in the 1960s and 70s when we got the Age Discrimination Act, the Title VII, the Occupational Safety and Health Act, and ERISA. And then in the 90s, we got the ADA and the Family Medical Leave Act, and more recently, the Obamacare. But I think it's, again, really important to recognize that all of these laws sort of are enacted on the same people and the same groups of workers, but they're enacted in very different ways and through different ideological schemas. So again, the individual rights the onus is often on the worker to enforce those rights, him or herself or their self, as opposed to having a political entity like a union ensure that labor standards are up to par.
So that let's slow down that history a little bit and get into the sort of the first stage of the now that we have a sort of overall sense of the architecture and even a little bit of the trajectory of the history. Veena, can you take us back to, let's say, the New Deal and talk about when labor and employment took its modern form and just lay out the sort of basic legal architecture in a little bit more careful detail?
Yeah, absolutely. Sure. And I think I'm going to give you a little bit of the history, and Kate can expand. But I think it's often said in a sort of straightforward, dispassionate way that during the Great Depression, government ushered in this protective legislation that we now know as the New Deal, and this is where we get our labor, the basis of our labor and employment rights. And I guess this is sort of a shorthand, maybe misleading way to understand how we got this regime that we have today. And I would even go so far as to say that it's problematic for two primary reasons. One, it really situates employment and labor law protections, the ones that we currently have, as potentially outdated. So this is the argument that we hear all the time from the Chamber of Commerce. The industry argument is to undermine these protections is that these New Deal laws were written as a government response to economic problems that were historically specific, response to a very specific type of industrialization, and they don't apply to the modern workforce. And that's an idea that I'd really like to trouble, and a topic maybe that we can return to later on in this conversation. But the second reason that I think just saying that government stepped in and created these rights for workers is problematic is that it discounts the tremendous role that people and movements played in making this happen. And it erases the central role of workers and even small businesses in engaging in decades-long radical struggles against the growth of concentrated capital and the exploitative working conditions that came with it. So some of the laws that we've mentioned, namely the Fair Labor Standards Act, the National Labor Relations Act, and the Social Security Act, all of which came about during the New Deal, weren't written because of the beneficence of good government, but rather I think were responses to social movements that respond through and with labor unrest and agitation. So from the earliest days of the Industrial Revolution, you had workers banding together to form labor bodies, fighting for a shorter workday and higher wages. And I think Kate can talk more about the folks that were involved in the debates, but we saw a growth of trade unionism over many decades. And it's fair to say that I think during the Great Depression, we saw widespread worker insurgency and radical organization that facilitated the passage of these laws. Whether the NLRA was a co-optation of this labor organizing that was intended to de-radicalize the working class, or whether the New Deal laws were intended to grow and protect labor organizations and usher in industrial democracy, these are fair debates that that we can talk about today or later. But either way, I think the New Deal laws are largely understood by historians not just as the sort of beneficent government response to the conditions of the Great Depression, but to growing demands and agitations of the labor movement. And I think that is so critical to understand in the labor movement today as we think about the kinds of changes we'd like to see, the kinds of legal changes we'd like to see. Since at least the progressive era, which was roughly, late 19th century, early 20th century, workers and their allies had been fighting for what unionists call a living wage, which was an income sufficient to sustain working class family and dignity. And the idea of a living wage was really opposed to a social wage, which was something that feminists of the moment were articulating. And I think the idea of a living wage was really shot through, and it continues to be shot through to some extent in this moment with racist and patriarchal assumptions, but it was still a radical critique of the capitalist marketplace. And so the laws that the progressives, in the early part of the 20th century tried to pass to achieve this living wage were largely found to be invalid by courts during and before the Lochner era, and combined with what we saw with regard to labor injunctions and the judge-made laws that really stomped out labor insurgencies, it led to a form of volunteerism in the labor community, in which the syndicalist left really saw the state as necessarily an apparatus of repression. So this is very different. This perspective is very different from the New Deal perspective, the sort of what we now call the Keynesian compact. And then of course we had World War I and the social turmoil of its immediate aftermath, in which the union movement tripled in size, and we had this monumental post-war strike wave. And the strike wave, it's important to note, was largely a response to the inequalities that had resulted from the increased concentration of wealth, largely through monopolization, a time that that we are that is that we call the Gilded Age, that we often compare ourselves to right now. And it was sort of this downward spiral of inequality and poverty during the Great Depression that led people to begin to wonder whether American capitalism had failed. And an understanding grew, I think, both in factions of the labor movement and in government, that to save America, to save American capitalism, the state would have to restructure and continuously regulate the relationship between capital and workers, which is how you went from sort of from on the one hand the sort of the volunteerism, the attitude of volunteerism in the left labor community, and the attitude in courts and from courts particularly, but also and some states sort of anti-work regulation, to this place at the New Deal where we created a regime in which workers have both collective and individual protections. And sort of a brief and crass overview of the history that preceded the New Deal, but it gives you sort of an intellectual history of how that happened.
Thanks, Veena. Kate, can you fill in a little bit on the movements that led us there, and also maybe fill in a little bit about what the resulting regime was? What is the NLRA? What is FLISA? And what are these laws, and what did they do, and how do they work together or not work together?
Yeah, absolutely. And just to underscore and underline a bit more of what Veena said about the sort of early part of labor history, I mean, that we began to see worker insurgency in the early 1800s. And I think it just cannot be emphasized enough the degree to which that insurgency was met by repression, by the law. First, using criminal conspiracy, where workers were criminally indicted and prosecuted for engaging in collective activity. Then over time, when juries increasingly refused to convict, using civil conspiracy charges. And then after the passage of the Sherman Act in 1890, using federal antitrust law and federal courts to enjoin worker collective activity. And so that conflict between, and then at the same time, as Veena was saying, courts striking down protective labor legislation like wage and hour law and health and safety laws. And so for a long time, labor was very much fundamentally in conflict with courts, and that really and with the state. And so, as Veena said, that produced an ideology in some corners of labor, and particularly in the American Federation of Labor, a real anti-statism, a commitment to private ordering of labor relations. That, though, was somewhat countered by the more socialist and industrialist unions, who said, whose view was, well, if the state is this hostile to labor, the goal can't just be to sort of escape from court injunction, escape from state power, but has to be to democratize the state and move towards either social democracy or democratic socialism, or a more democratic system. And so the industrial unions, which eventually became the CIO, were committed to organizing not just craft workers, not just skilled workers, and not just white men, but to organizing everybody, to organizing immigrant workers, organizing women, organizing African Americans, Black workers in the South, and trying to organize like wall to wall, so that not separate unions for skilled workers and different organizations for unskilled workers, but organizing everybody. But then in organizing massive industrial strikes, brought the power of the state, not just courts, but federal troops against workers' action. So the New Deal from labor's side was shaped, and the legislation that emerged in the New Deal was shaped both by the CIO ideology, or it wasn't yet the CIO, but the industrial unions ideology, and also by the AFL ideology. So it's kind of it produced a mix of a sort of anti-statist voluntaristic system. For example, the Norris-LaGuardia Act, which was one of the first bills passed in the New Deal, removed jurisdiction from federal courts so that they could no longer enjoin workers' collective action. But in contrast, NIRA, the National Industrial Recovery Act, embraced a more corporatist or tripartite system, which tried to bring workers, business, and the public together to set wages and industry standards on an industry by industry basis. That was obviously struck down by the court before the sort of switch in time. But the subsequent laws that emerged, like the NLRA and the Fair Labor Standards Act, did both of these things. So the NLRA, in some ways, embraced a very voluntarist system where workers organize at a firm level and then get the right to collectively bargain with their individual employer. It's not the state pulling everybody together in the whole industry and requiring bargaining by employers to sort of settle the terms, and unions to settle the terms for the whole industry, which is more like what you have in most European countries. So it's voluntarist in that sense. But the early National Labor Relations Act aspired to, or the advocates for the National Labor Relations Act aspired to wall-to-wall unionism, for unions for all, and aspired to have workers gain enough power through this voluntarist system to be able to sort of help set the direction of the political economy. And in terms of sort of what the coalitions were, so there's the AFL, the CIO, we have progressive intellectuals like John Commons, like Dewey, Louis Brandeis, supporting this move towards rights to organize, and the goal of having workers in business sort of collectively set terms. But as we already sort of emphasized, the original, the NLRA and Fair Labor Standards Act very deeply reified exclusions, and they ultimately represented a settlement between the unions, FDR, sort of New Dealers, and Southern Democrats, and the exclusions of agricultural workers and domestic workers were absolutely sort of a compromise with the South to exclude Black workers. And then the other thing I think, we currently think of the Fair Labor Standards Act as really just being about individual rights, but the original Fair Labor Standards Act actually did include a mechanism for unions and business and the public to jointly set wages for entire industries. And the advocates for that saw it as a way to try to extend the benefits of unions to all workers, including very low wage workers, including workers in the South. So the original New Deal, in many ways, was much more progressive than the one that were the post-1947 statutes that we're really left with now, because it did include much more protection for strikes, for example, but also systems for extending the benefits of collective bargaining to all workers in industries.
Thanks. So I want to turn to the sort of reactionary turn in the moment, and whether it's the neoliberal turn or whether it comes before that. But before we do that, I think it might be worth laying the groundwork about the other elements of employment law that Veena mentioned, and just briefly talk about what forces called into being. And it might be relatively obvious, but what is the Civil Rights Act and other employment protections.
Maybe I'll talk about those things a little bit, and then talk a little bit about the neoliberal turn, because I think it's relevant. This is not my expertise. If you're interested in this, I highly recommend a book by my colleague Roel Schiller called Forging Rivals, which is a history of the relationship between the civil rights leaders and labor leaders during the 1950s, 60s, and early 70s. But essentially, the civil rights model of, in large part, I think, because there was a lot of racism. I mean, to put it again bluntly, in the labor community. I mean, some of the first Title VII cases were actually against the building trades unions, and so there was a fissure between the mainstream institutional labor community and the civil rights community in many settings and contexts, not in all. But as a result, when the Civil Rights Act was passed in 1964, maybe not as a result, but part of this is that what we got was an act that maybe didn't have a lot of faith or trust in unions, or in B, in the collective enforcement of rights. So we had Title VII is essentially, although possibilities for class action, it's an individual rights-based model of thinking about discrimination in the workplace, and then it protects people from because we have a system of at-will employment in the United States, which is not true in Canada. It's actually not true in Montana, randomly. But for workers who are not unionized and not in the public sector, for non-unionized workers in the private sector, so most everyone, you can be fired for no reason at all. Doesn't have to be a bad reason, as long as that reason is not illegal. So as long as you're not being discriminated against because of your race, your religion, your national origin, your age, your disability. And in at-will, I think the regime of at-will employment, specifically as it exists outside of the union context, is so debilitating in terms of how and whether people can enforce their rights. So all of the other employment rights that we have, the right to a minimum wage, the right to unemployment insurance, to workers' compensation, all of these things are left to the worker to enforce themselves. And so, there are state enforcement agencies, of course, but very, very limited in their capacities, and go after big bad actors, and often not there to enforce every single individual person's right. So there's, again, I'm taking us back to what Kate began talking about, which is how our regime is really bifurcated in this way. So I'm trying to, I know that there are people who are listening who know everything about employment and labor laws. I'm trying to strike some balance between people who don't know and people who do know, but we have we have the Fair Labor Standards Act at the federal level, which sets the minimum wage. It's been set at the same number for the past 9 years, $7.25. It also gives us overtime protection. I'll just give another few important ones. Social Security Act, which created the regime of unemployment insurance that is really administered through the states, but as many of you have probably encountered this regime more recently, it's interesting to note that the unemployment insurance laws were actually written in opposition to the notion of the social wage. Again, there was, the feminist, more more equality-oriented activists who were pushing for a social wage. What we got out of that was unemployment insurance, which was really, when it was passed during the New Deal, seen as a more conservative way to provide a safety net protection, because again, it didn't protect everyone. You have to make sure that you are only laid off through no fault of your own, so that it was distinct from sort of a welfare provision, etc. So those are sort of the key employment laws that was there another one that you wanted me to mention or talk about? You look like you're about to say something, Luke.
No, that's great. Sorry, my family's walking through the room as I
was like, I can't tell if I'm totally failing you here, or but so let me just talk about the neoliberal shift more generally, and it really it takes us from the collective to the individual. So ideologically, of course, there was this shift in the legal academy in the early 1970s, where we witnessed revisions and understandings of things like monopoly power and the efficacy of unions, perhaps most starkly demonstrated by Bork and his antitrust paradox book. But these ideas, these sort of laissez-faire, free market, and maybe in another time we can talk about how these terms themselves are problematic and how there's no such thing as the free market. But these sort of conservative ideas called into question things like unions and collective power. And of course, this is happening amidst the Cold War, amidst fears around socialism and communism. And this growing sort of conservative intellectual movement was, we can see it across disciplines, but certainly really, really embedded and effective in law schools, and thus, actually had an impact on policy. And so structurally, sort of ideologically, structurally, from a legal standpoint, I think it's largely agreed upon that Taft-Hartley, which was passed in 1948, set the stage for the massive neoliberal shifts that we saw in the 1970s that resulted in the decline of political power among the working class, the decline of unions, and the shift from collective power to individual rights. I had mentioned Taft-Hartley earlier as being the law that amended the National Labor Relations Act to carve out independent contractors. And I want to use an example of this to sort of talk about the other structural shift that we saw impacting workers and labor and employment law more broadly during the 1970s into the 80s, 90s, and sort of continuing in more extreme ways today. And that is sort of growing and using the concept, David Weil's concept of fissured workplace. So for those of you who maybe have not read The Fissured Workplace, I really highly recommend it. It's such a really easy, good introduction to the phenomenon that you see all around us. But there was a moment in the post-war period, in post-World War II, where we really saw the fruits of the New Deal, where we had, high unionization, stable employment. You had this notion of what Jacob Hacker has called welfare capitalism culturally, where companies really saw themselves as being as existing not just for the sort of profit margins of their shareholders, but actually to take care of their workforce as well. And a single employer would, and this is true still for many mom and pop small businesses in the U.S., but a single large employer would employ not just the core workforce that did the core work of the firm, but they would also employ the janitor and the gardener and the caterer, all of the various workers who made up the peripheral aspects of, did all the peripheral but essential work. Again, I often think of Sylvia Federici saying, without women's labor, the capitalist system would collapse. There would be no workers to do all of the work that the corporations want us to do. And the same can be said of all of these non-core sort of peripheral workers of these firms. Again, the people who clean, the people who make the food, the people who do the secretarial work, etc. And so starting in the 1970s, in order to get out from the responsibilities that the New Deal put on employers, to not have to pay into unemployment insurance, not have to pay for workers' compensation, to not have to worry about wage and hour lawsuits, companies started to focus primarily on their core competencies and contract out the other things. And so just to give you an example of what we have today, if you go into Google in our YouTube office, which is just down the road from me here in San Bruno, you walk into this into YouTube, and there is security guards. There are people at the front desk. There's like this big, beautiful, amazing cafe that you just want to sit in all day long, and there are people who work at that cafe. None of these people work for YouTube. All of these people work for contractors. They are often employees of a staffing agency or a contracting company, like the caterers all belong to Bon Appetit, but they are not employees of YouTube. And so it is much easier for YouTube to disclaim responsibility, and it becomes much harder for these workers to unionize as a result as well. It also makes it harder for them to enforce all of these various individual rights. Independent contracting, so that's sort of contracting. The other thing that we see in the fissured workplace is the growth of independent contracting. Now, independent contracting, as much as there has been made about it, and I almost focused my entire scholarship on independent contracting, represents a very, and continues to represent a very small percentage of the U.S. workforce. That said, it is a growing percentage of the U.S. workforce. And when Taft-Hartley carved independent contractors out of the National Labor Relations Act in 1948, it really went unnoticed. There was only one law review article that was written about it, and there was very little discussion in the legislative history. But soon enough, clever employment and labor law lawyers working for firms realized that this was a really brilliant way to get out from under the risks and financial liabilities of employment. So, for example, in the late 1950s, taxi companies wrote to the IRS and they said, if we stopped leasing if we stopped paying our workers by the shift, ensuring a minimum wage, et cetera, and moved to a leasing model where they actually come to us, pay us $100 for 10 hours and take the taxi, does that make them independent contractors? And the IRS said yes. And so over the course of, I see Anna's, yes, I agree, Anne. But I can talk to you a little bit more about how there's a misnomer about independent contractors in tech. So I'm sorry. So you know, the courts, the IRS said yes, these are independent contractors, and this was actually used to de-unionize the taxi industry. So in the late 1970s, the unions, you know, sued and said, this is in violation. You're doing this, it's in violation of our agreement. And the court said, well, it's not subject to collective bargaining because it's a business decision. And so this led to the deunionization of the taxi industry, the fissuring of their workplace. All of these workers all of a sudden were without a union, without employment and labor law protections. And now sort of, you know, fast forward 30 years and you get Uber and Lyft, which is just the same thing, except for now, in addition to these workers being treated as independent contractors, you also have the workers bearing the legal and instrumental risks, like owning the car, having to buy their own insurance, etc. So it's sort of even much more extreme sort of answer to the New Deal model. There was just a quick question I wanted to mention about independent contractors in tech. Actually, so it is true that this fissuring model has long existed in tech. Microsoft did this, started using subcontracting to staffing agencies as early as the mid-1980s. But most of the people in tech, especially white collar workers, are actually employees of the staffing agencies. So they have you know, protections like minimum wage, workers' compensation, unemployment insurance. They're not independent contractors. There's actually very few real independent contractors in the white collar tech workforce. But in the blue collar tech workforce, there are many, many, many independent contractors. And interestingly, and I can talk about this in Q&A, there's been a lot of solidarity being built as a result of this this fragmentation, this fissuring of the workforce, because they recognize that this very similar things are happening, despite the fact that their salaries are very different.
So maybe just to jump in a bit more on like the effect of the neoliberal turn, or how to understand how that fits in with labor history more generally. So I think I agree with Veena that the 1970s and the 1980s represented a significant attack on labor, and that was part of the broader neoliberal turn. And in addition to the example she gave of the sort of decision to start subcontracting out work and creating independent contractors in order to avoid legal responsibility, we also saw employers moving work overseas, moving to temporary work, and engaging in strike breaking, especially after Ronald Reagan replaced the air traffic controllers, aggressively using permanent replacements when workers went on strike to try to fight these changes. We also saw a growth of the right to work movement. And courts, again, played a role in permitting all of that. For example, by saying that employers didn't have a responsibility to bargain over things that were entrepreneurial in nature. They might have to bargain if their intent was to discriminate unions, or they might have to, that might be illegal, or they might have to bargain about effects of these decisions. But fundamentally, these kind of entrepreneurial questions were for employers alone, and workers don't have a right to bargain over them, or at least there's no mandatory obligation to do so. So in that sense, the 1970s and the 1980s were, a terrible time for labor, and represent a significant turn. But as Veena alluded to, in some ways it's the wrong periodization for labor, because these changes really were baked into the law in 1947 when the Taft-Hartley Act was passed. So in addition to the carving out of independent contractors, the Taft-Hartley Act included an obligation for union officials to take a non-communist oath that not only helped purge communists, but helped purge, basically effective in purging many sort of left-leaning people from the from unions. It included a prohibition on secondary boycotts, which was really, really devastating to workers' ability to use concerted action, strikes and boycotts and pickets to affect power across, sort of to exercise solidarity across employers, and to try to use their power to help other workers, or to the secondary boycott prohibition basically prohibits striking, picketing, putting coercive economic pressure on entities that aren't employees' own employer. And it enabled states to enact open shop right to work laws, which really hobbled the efforts of the CIO to organize in the South, but also sort of created the system where we have basically many non-union states and some union states. And actually, again, that I think was a misinterpretation of the statute, but it is the one that was ultimately adopted by the court. The Taft-Hartley Act included a provision that protects employer free speech, so employers' right to campaign against unionization, making it clear that when employers speak against unionization, as long as they're not threatening, it's protected. It can't be an unfair labor practice. And in some ways, even blaming it all on Taft-Hartley is wrong, because as Carl Clare has pointed out, even, and we're going to get to hear from him later, but really right after the Wagner Act was enacted, it started getting chipped away at in court. So yes, on the one hand, the neoliberal turn was extremely devastating for workers and worker power. At the same time, it all started much earlier for labor, including very soon after the passage of the NLRA, we see business transforming Lochner-type due process arguments into First Amendment arguments. We hear a lot about that today, the sort of Lochnerization of the First Amendment, but in labor that started in the 1940s. And more broadly, there was a dismantling of wartime and early New Deal mechanisms that were more sectoral bargaining or statist attempts to try to set standards for all workers. So by 1955, when the AFL and CIO merged, there was a solidification of the private voluntarist system that was good for the workers who were covered, good for workers until the 1970s, right? But excluded many, many workers. And then finally, I think the other problem with focusing on the 1970s as this terrible moment, as the source of all ills, is that in some ways, the 70s and 80s and 90s also were a period of growth for labor for different kinds of workers. So you start seeing organizing by public sector workers, actually before then, but continuing teachers, the Justice for Janitors movement, healthcare worker organizing with 1199 that later merged into SEIU, organizing later among home care workers and domestic workers. So it's too simple a story to sort of locate all the problems with the 1970s and the neoliberal turn, I think.
Thanks, Kate. So I want to move us up to the present, but I guess I briefly want to ask one question, and if you guys think it's if you want to toss it, that's fine. But my question is, so all of these attacks on labor are happening, and ostensibly the Democratic Party, starting with the New Deal, the Democratic Party was the party of labor in this complicated way. Can you guys address a little bit about how labor and the Democratic Party divorced during the neoliberal period, or is that too complicated?
I mean, it's like a book. You want to talk about it, Luke?
Do I want to talk about it?
Yeah, what do you think?
Well, no. I'd rather you guys talk about it.
Well, I mean, it is important to emphasize, right, that the Democratic Party, despite having a majority in multiple periods over this time, failed to enact labor law reform, failed to prioritize labor law reform, and ultimately much of the Democratic Party adopted kind of a lot of the neoliberal ideas about the importance of efficiency and contracting, the problems with workers having a voice or having power over their jobs. And it's not, by no means was that monolithic, but it was enough of the Democratic Party to supporting like free trade without labor protections. There are just countless examples of workers feeling abandoned by the Democratic Party and of the Democratic Party not prioritizing workers' issues.
And I was just thinking about this today about how, you know, Carter actually signed the Airline Deregulation Act, and I think that part of what was happening there was very like, there's an intellectual history that we could talk about, but there's also just an elite history that we could talk about in the ways that these people who were advocating this point of view started to find their way into the Democratic administrations, were appointed as economic advisors, et cetera, and really shaped in the name of freedom and individualism, really shaped even the real politics of what happened during Democratic administrations.
Thanks for going with me there. So do you, Kate, start with you. Do you think labor and employment is in crisis right now? And,
I mean, clearly, right? Sorry, go ahead. I cut you off.
No. And what are the cracks? And yeah, talk about it.
Yeah, I mean, the crisis is so obvious, right? And it's so particularly urgent now, and we see it so clearly exposed by COVID, by the sort of the extraordinary vulnerability and lack of power, and the economic crisis that workers, particularly workers of color, immigrant workers, are enduring right now. And, you know, it's evident in terms of the staggering economic inequality that defines our country. It's evident in terms of the lack of freedom, of democratic rights that workers experience on the job. So there's no question that there's an urgent, dire crisis in the field of labor law and facing workers. You know, I think we've already hit on what some of those really important ones are: the exclusions of lots of people from having rights under our law, of being conceptualized as rights holders. We haven't even really mentioned Section 7, which is the core part of the National Labor Relations Act that gives workers the right to engage in concerted action free from retaliation, at least purports to do that. And in some ways, that's super radical, and it gives workers those rights even if they aren't unionized. And we see workers taking or invoking those rights now. Non-union workers going out on strike to protest health conditions, to protest sexual harassment. And in some ways that's quite radical and really different from a lot of other countries' labor regimes. But at the same time, the law really in practice doesn't effectively penalize employers for violating Section 7 rights. There's almost no enforcement mechanism. So for example, if a worker is terminated for engaging for exercising Section 7 rights, for engaging in collective action with coworkers to protest terms and conditions at work, the remedy is many, many, many years later, back pay minus any reinstatement, back pay minus any wages earned in the meantime, with an obligation to mitigate, to work, not only because you have to live, but because law actually requires you to. So there's essentially no, it's economically rational in sort of the law and econ folks' terms for employers to violate the law. We talked about the prohibition on secondary boycotts, the ability of employers to permanently replace workers for striking. There's also bans on mass pickets. There's bans on what's called intermittent strikes, so sort of shorter strikes. We talked about the employment at will system. And then we talked about, so I think another, just sort of stepping back, is like the mismatch between what the economy looks like and the system that is set up. Both, in fact, just today, the NLRB issued a decision limiting the definition of employer, making it harder for workers to hold entities who actually have control over their jobs responsible. So for example, McDonald's doesn't actually employ all of the McDonald's workers. It has franchisors who employ the McDonald's workers. And so the question is McDonald's a joint employer? Or the question sort of in this broad area of laws is McDonald's a joint employer? The NLRB today just made it harder to hold sort of apex corporations as joint employers. And then the fact that we have the system of private bargaining where workers aren't really given sort of official power to set the direction of the political economy or to negotiate about social welfare benefits. So many cracks, right? And so many problems of crisis. At the same time, and maybe I'll turn it over to Veena for this, but like it's also, I think, a moment of optimism in the field for a bunch of reasons.
Yeah. I would say that not only is labor and employment law in crisis, but I would say workers are in crisis. And just, to give you a very, very recent example of the ways in which all the things that we're talking about come to a head in people's lives. I'm a legal anthropologist. I have long done an ethnography of a group of drivers who are organizing in California, the Rideshare Drivers United, and they want a union. During the Trump administration's, or we're still in the Trump administration. I've moved past it, but I realize we're still in it. In the Trump administration, wrote a really stupid memo. That's my new legal word, stupid. A really stupid memo that said that these workers that are totally controlled in every way in their workplace are independent contractors for the purposes of the NLRA, and therefore do not have the right to collectively bargain. It doesn't have any legal authority. It's just an opinion memo, but it tells us how, under the Trump administration, how the NLRB would rule when the companies challenge these workers' rights to form a union. So we have these workers who think of themselves as a union. They call themselves an undocumented union because the law doesn't recognize them, and they're organizing every single day. They, when the pandemic hit, all of a sudden, a few of the workers that I organized with came down with COVID because they have been exposed to, obviously, to passengers coming from the airport who had the coronavirus. One of them actually died in the process. That person does not have workers' compensation, anything for his family. The one that survived, tried really hard to get paid sick leave, was not able to get paid sick leave, even through the company's sort of privatized paid sick leave policy. And then everyone is filing for unemployment insurance. Now, under California state law, Uber and Lyft drivers have been getting unemployment insurance since 2016. But because these companies have not been paying into the unemployment insurance fund, and all of a sudden you had 500,000 Uber and Lyft drivers, along with millions of other workers across the state, applying for unemployment insurance because we're all in quarantine, the state was giving them federal unemployment insurance. So when the CARES Act was passed in late March, early April, the federal government temporarily created unemployment insurance for independent contractors, and this was, through really progressive lobbying, and also through really, terrible lobbying. And of course, Uber and Lyft and all of these gig companies want the federal government to continue to treat these workers as independent contractors. So they were pushing for this legislation, but the legislation gave full-time drivers hundreds less dollars per week than they were owed under state unemployment insurance. So these workers were really put in this horrible bind where they've been told by the state that they're employees, that they are owed unemployment insurance, but then they're getting hundreds of dollars less per week under the CARES Act per PUA. And these are low income people for whom $200 is a week is a lot of money. I mean, it's a lot of money even I think for anyone. And so that's a sort of real world consequence of the ways in which the labor and employment laws are failing us now, 5 months into the pandemic, 6 months into the pandemic. A New York court told the Department of Labor in New York State that they have to give drivers, Uber and Lyft drivers, state unemployment insurance. The Pennsylvania Supreme Court said yesterday or the day before, you have to give these drivers state unemployment insurance, and we're in the same situation in California where workers are in a position to sue for the same rights. Hey, sweetie. Just a couple of other points. I think that I've mentioned a lot about how in the non-union context everything is individualized, and it's very, very hard to enforce your rights because you're in sort of relative powerlessness in a relationship to your employer. But this is exacerbated by arbitration, by mandatory arbitration, which is a ubiquitous aspect of all of the contracts that we sign. I actually just signed a contract for my daughter's preschool that had a mandatory arbitration clause. And there's a series of Supreme Court cases, from AT&T, Concepcion to Epic Systems more recently, that have cemented arbitration into how we adjudicate disputes, both as consumers and as workers. And so what this means in practice is that when the drivers, my friends that I organize with, when they are pissed off that they're not getting paid what they're owed under California law and they want to sue someone, the court says, oh, sorry, we can't take your case because you signed this arbitration agreement when you clicked yes on your phone, and that means that you have to go to an arbitrator. And you know, no plaintiff's attorney will take these arbitration cases because there's no money to be had. There's only money you know, in class actions, and so it's really effectively undermines the ability of workers to even individually enforce these rights that they have, but also critically it undermines their ability to collectively enforce these rights through class actions. And just one small thing that I would be remiss if I didn't talk about, because I am, you know, a student of Lauren Edelman, but also there's been a whole growth in this HR movement since the 1970s, which has also sort of counterintuitively made it harder for workers to have their grievances addressed in a court of law. One bright spot that I've seen more recently is the growth of minimum wage laws at the municipal level, and you've seen this sort of most starkly in SEIU's Fight for 15. Movement to raise wages in the food industry and, you know, beyond. And so we saw even Amazon a few years ago raise their warehouse workers' wages to $15. You know, that number came from the Fight for 15, of course. But you know, the reality is that without a union, what happened is that the workers got their $15 and then they lowered their hours and they lowered their benefits. So the actual amount of money that people were taking home, you know, overall per person ended up being a very negligible difference. The companies found another way to sort of cut costs, and so you know, I say that in particular, and want to end on that in particular to really elevate and draw attention to the importance of Kate's comments on all of the ways in which unions are undercut and crippled by existing laws and decisions.
Thanks, Veena. So Kate, do you want to say a little bit more about green shoots and hopes you have, and then we can bring in our guest and go to Q&A?
Sure, I'll just say a couple words because there's so many amazing questions, and I don't want to take up too much time. But I do think I also on the one hand we're in a moment of despair where the legal system is failed. On the other hand, I think it's also a moment of optimism because there's extraordinary organizing occurring among workers, and it's not just sort of random protest. It's organizing that actually is advancing a really different picture for what law should look like, for how society should be organized, and we can sort of get into more detail during the Q&A, but you know, I would put chief among this the organizing happening among gig workers, but also the Red for Ed movement, which is objecting not only to low wages for teachers, but austerity politics and bad conditions for students. The Fight for 15 movement, which Veena just talked about, which is really showing a way towards a system of more sectoral bargaining of rights for all workers throughout industries. There's just some extraordinary organizing happening among workers, and we should take that seriously and reason up from that about what a legal regime might look like that really effectuates their goals, their aspirations. But one other question that Luke sort of foreshadowed for us is sort of, you know, what about the sort of failure of what about the academic field, the state of the academic field? And I think Veena and I both, in reflecting on that, maybe unlike many other fields which were sort of dominated by law and econ or neoliberal ideas, labor law, we sort of step into a really rich tradition and of really extraordinary scholars. One of whom we're lucky enough to have on the screen now, and we wanted to just turn things over to Carl, to whom we're both very indebted, I think, in the way we think about these issues.
Thank you so much for having me. It's a real honor to be invited to discuss your panel. I just want to say what a magnificent job you've done in compressing so much historical and contemporary and analytical information into such a short but powerful presentation. And the presentation was very nuanced. I think we're all grateful that you not only pointed out the sad and sorry parts of the story in the past and in present, but also the high points and the reasons for optimism and the possibilities of moving forward. I guess the one comment I just wanted to underscore 2 points. It's not really different than anything either Kate or Veena said. Simply reinforcing. One is that my parents were in the labor movement in the 1930s. So when I grew up, they took me to union picnics and so on. So the idea that the labor movement, with all its faults, and I don't mean to erase the racism and sexism and so on, but for all its faults, it was a people's movement. It was a radical movement. It was, and this was the appearance of the National Labor Relations Act, as both Kate and Veena said, it was not some beneficence of government. It was something that was achieved through the courage of working people and their bravery and imagination. And I think it's easy to lose touch with that. I think there are not many people in law schools now, maybe, who have a direct connection with labor as an activist movement. To tie to last week's program on movement lawyering, I thought it was fantastic that you reminded us of that part of our history from the earlier in the 20th century. The other thing, again, just echoing what Veena and Kate said, I think both in the academy and more generally in politics, I think we should be cautious about over-exaggerating the neoliberal turn in the labor field. Some terrible things happened in the 70s and 80s for labor, no doubt about it. But as Kate and Veena showed, the struggle between workers and capital has been shot throughout the history of labor law, from the beginning to the end. And the big conservative move was in 1947 in Taft-Hartley. I don't even know if Robert Bork was born at that point, but and moreover, as you laid the story out, it's not a question that in times of rightward drift, when capital was getting the edge over labor, that necessarily the way that expressed itself legally was in a return to market logic or freedom of contract. Very often quite the opposite. The form of repression was what we would call regulatory in nature, social control. Not that any of us believe that there's such a thing as a free market or an unregulated market, but leaving that aside. So Taft-Hartley, it was as Kate was talking about, the 8B4, the secondary boycott prohibitions, and even the Section 301, which led to the complete undermining, in an opinion by Brennan, the undermining of the Norris-LaGuardia Act 20 years later. So the question within labor law has never been, should we have the market logic or the logic of social control or social democracy, because both markets and democratic politics, they each embed individualist and collectivist, selfish and altruistic values. So what it really is a question of is radical reconstruction, egalitarian reconstruction of markets, pushing the content that we want. So that's just a footnote, really, and a way of reinforcing what Kate and Veena laid out for us. But I just want to, we should go to Q&A. I just want to say how astonishing your survey was.
Thank you so much, Carl. So yes, let's go to Q&A. We're running a bit short on time, but we'll do as much as we can, and maybe we'll have folks stay over if folks are feeling comfortable, because there's a lot of really good, rich questions. So let me ask I'll try to sort of combine some questions since a lot of them are thematically linked, but let's start with Cosmo Pappas's question, which is at the top. What area of labor and employment law today has the most potential to push the envelope on the overall balance of power between labor and capital? Is it at-will employment, ending independent contractors? And then I'll just note that you know, the next couple questions are related to this question. So I'm going to frame that question overall, but then Beth Patel asks, do you think the model of sectoral bargaining has a future for potential in the U.S.? And I know obviously Kate has a lot to say about that, so maybe that's a room for hope. And then Bem Palmquist asks, can you say a bit more about possible pathways toward effective enforcement of workers' rights, especially for independent contractors, domestic and agricultural workers, and other excluded from systems of production? So these are sort of questions about places for hope and maybe what the most place for hope is. Why don't we start with Kate, and then we can go with Veena.
I'm not sure I can settle on one area of labor and employment law, in part because for all the reasons we've been talking about, the problems are so interconnected. I think ending employment at will would be a huge step because it would give all workers sort of more power to enforce their rights at work without being afraid of always being sort of at risk of termination for no reason at all. That said, you know, I think it's important to think much more broadly. So I guess I would maybe put add 4 additional things. Oh, and unemployment at will, I just want to give a quick shout out. Jared Odesky, who I think is on the call, wrote a terrific write-up on the issue on the On Labor blog, which is worth checking out. So eliminating the exclusions, number 1, and you know, lots of ways to get there. But number 2, creating essentially real rights of worker voice at all work sites, so that workers have real right to organize and bargain at the work site. And that includes, number 3, creating a system of sectoral bargaining, so that we don't have a system where each work site is sort of in competition with one another in terms of wages, and where unions have a seat at the table to set basic standards for the entire industry, which exists in most European countries in one system or another, most industrial democracies. And number 4, protecting concerted action rights, strike rights. Because without being the ability to exercise that kind of collective power, so many of these other rights really don't come to anything. And just one more word on sectoral bargaining. I do think there's hope for moving towards that system, and in part because there are ways to do that at the state level. That's sort of in a model that's been, I think, that's emerged in part from the Fight for 15 movement, which is that because federal preemption is extremely strong with respect to labor law, but leaves states a lot of room to regulate with respect to employment law. It is possible for states, and a number have started to do this or already do this in some ways, to bring worker organizations and business to the table to set employment standards on an industry by industry basis. That is not preempted. And so that kind of reform can happen in progressive localities, even where federal labor law reform is impossible. And I think it's really important to resist the idea that the United States is so exceptional, so different from the rest of the world, that we can't have a system where all workers have benefit from the fruits of collective bargaining. And in fact, it's ahistorical. We have had that at moments.
So I just want to agree with everything that Kate said. I would elevate all of the changes to worker agency under the National Labor Relations Act really to the very, very top of my list of things that need to be changed, really putting power in the hands of workers themselves to enact the kinds of shifts and positive changes in their own working conditions, getting rid of the secondary boycott, making it easier for them to organize in their workplace. You know, all of those things. I actually linked to a really great report that Kate co-wrote that articulates some of the specific issues with the NLRA that could be changed. And there was actually an act in Congress, the PRO Act, the Protect Right to Organize Act, that was introduced in this last session. You know, was not going to pass the Senate, but there was a lot of really exciting, good discussion. Again, I think that is only happening because we've seen a record number of strikes in the last 2 years, more work stoppages than we have seen since the early 1980s, which is really quite something, because there's such rampant inequality and people are so sick of it. I do want to just, and I don't want to end on a negative note, but I do want to highlight the ways in which sectoral bargaining has become kind of a sexy term in the labor community, and it's something that a lot of the presidential hopefuls have been putting out there, in large part because the unions the SEIU in particular has been really pushing this idea of sectoral bargaining, which I think is a good one. But the way that I saw it play out in California in particular, there was an attempt after in the midst of this fight for this law, AB 5, which would give workers basic employment rights under California law, there was an attempt to come to a compromise. And so not only are unions talking about sectoral bargaining, but there's this new coalition of horrible, like the worst employers you could possibly imagine that are really excited about sectoral bargaining because the devil is in the details, right? So what this looks like, it can be really, really amazing and empowering and fantastic, but it can also be really, really retrograde and take us even further away from the kind of industrial democracy we want to see. So the kinds of compromises that were thrown out by the companies and frankly some unions in California would have grown political power for the unions that were involved, but it really would have disempowered workers in the workplace. It would have lowered labor standards overall, and it was it was really disheartening. I don't come from the institutionalized labor movement, and I was sort of unaware of the sort of general politics, and I was upset to see the way something as progressive as sectoral bargaining was weaponized to a point where it would actually have lowered the floor instead of raising it. And so I think that it's and if you haven't read Kate's amazing paper, The New Labor Law and Yale Law Journal, I think you absolutely should. I think that there's a lot of promise there, but it doesn't. The Coalition for Workforce Innovation, which includes Manpower, Lyft, Postmates, all of the companies that have been chipping away at labor rights over the last many years. It is also on their platform of things that they want, and so we really have to, I think, be cognizant and cautious of using it as sort of a term that maybe that is an umbrella term that actually could have and be interpreted to mean very, very different things. There was one more thought I wanted to add to that. What was it? I think just maybe to end on something more positive, just, I think what is so striking to me is the way in which all of the organizing that I have seen and written about and taken part in, both with white-collar tech workers and blue-collar tech workers over the past many years. What's so amazing to me is that oftentimes they just don't care about the law. They don't care about the secondary boycott provisions. The gig workers in particular are like, what do we have to lose? Really willing to fight and use power to both shape the law in a way that benefits them, but also to shape their working conditions in a way that benefits them. And it's been as a lawyer, as someone who has been professionalized in the law, it's been really inspiring and revelatory.
So I think, let me ask one more question, and then we can also do maybe a round of wrap-ups as well. And this is maybe even sets our sights a little bit higher. So Jeff Wang asks, thinking about, for example, voluntarism and tripartism, how do workers defeat corporate capture of government? What role here can or cannot be played by lawyers and legal scholars? Veena, let's start with you this time, and then go.
Well, maybe I would refer you back to the talk from last week on movement lawyering, to the role that can and cannot be played by legal scholars in this. Oh my gosh, I'm getting in trouble. In this fight, there's a really rich tradition of legal scholarship from Gerald Lopez to Samir Asher on rebellious lawyering and the ways in which lawyers and public interest lawyers and academics and people who are otherwise in an elite position should be following worker movements and elevating them, and finding ways to get workers what they need instead of being sort of the voice or the policymakers, the policy setters. And so I actually take that really that principle to heart in my my own work. I don't know. I mean, our system is built to protect property, and so I don't know that there is that sort of what the question sort of sets forth, the vision that the question sets forth is even possible. I think there's always going to be corporate capture. It's just a matter of having enough political power to create, short of revolution, having enough political power to create some semblance of fairness and equality. But it's not how we're built.
Kate?
So I guess I would maybe take it in two parts like Veena did. The first is the question of like what role for lawyers. And I think there's so many different roles that lawyers can play, that scholars can play, that you can play, as a lawyer for a social movement, as a lawyer within government, and having the perspective that Veena was offering about sort of what role what hat you're wearing, and sort of how does your work as a lawyer not take on sort of you as expert, but you as in service of and helping movements, I think is critical. But the bigger question there is a worry about, that actually relates back to what Veena was warning about in terms of the ability of sectoral bargaining of sort of government system to become co-opted and not actually advance worker power. And then more generally, how might we imagine a government that actually is much more democratic? And I think, I mean, it's such a big question and there's so many different ways to think about it. But I do think that it's really important for people who care about worker power, who care about labor rights, who care about labor, to think of themselves not only as engaging in problems that are sort of worker issues, but as problems of democracy more generally, or problems of monopoly power, of banking, of corporate law, sort of the LPE effort more generally. That these are all one of the same project. And conversely, for when we're thinking about sort of democracy reforms, to not think about that only in terms of like voting rights or campaign finance, but what are reforms that really can help build organization among working people as workers, as tenants, as consumers, so that they can then exercise power to hold government accountable and to participate in government. And so I do think it's like a multi-layered project of reimagining our democracy. And I think for me, history is really helpful here, because I think, as Carl said, these problems are old, right? And they're in new forms, but there are many people who've come before us who've tried to wrestle with these problems. And so it's helpful sometimes to look back at those. But I absolutely agree with Veena's point, and I think it's implicit in Jeff's question, which is that for something like tripartism to work, there needs to be a strong labor movement and strong social movement organizations that can exercise real power at the workplace, in the community, and it cannot be sort of just a government bureaucratic endeavor.
Carl, did you want to add any thoughts on this question, and then we can wrap up?
Just to put italics around Kate's beautiful formulation, a multi-layered project of reimagining democracy, not imagining that happens at government level only, or at the local level only, but at all layers. Beautifully put.
Thank you. Well, so then I think that's a really lovely note to end on. Kate and Veena and Carl, thank you so much for joining us. Guests, thank you for joining us, including all the question askers. I'm really sorry we didn't get through more of them. And please join us next week, where we'll talk about the criminal legal system. And the week after, we'll talk about American Empire. Thank you, everybody.
Thank you.
Thanks, that was so fun. I really appreciate you guys putting it together and everyone spending their evening with us.
Likewise.
Thank you, Carl, so much for blessing us with your wisdom.
Thank you for having me. It was a thrill, and you really did. I don't know how you did it in an hour. You gave 200 years of history. It was fantastic, and it was accessible. You know. Anyway, congratulations.
Thanks, Carl.
All right. Thanks, everybody. Have a good night.
Take care.
Bye-bye.